Please be seated. The record will show the presence of the jury, the defendant, and all counsel. Good morning, ladies and gentlemen. Did any of you read, see, or hear anything about this case on the media? Please raise your hand if you did. Did anyone attempt to speak with you about this case? If so, please raise your hand. I see no hands. This time we will have an additional bailiff sworn.
You do solemnly swear to take charge of this jury and protect their deliberations from all outside interference, so help you God.
I do.
All right, ladies and gentlemen, we are going to begin the aggravating factor phase of this trial. The bailiff has some instructions for you. She will be handing those out at this time. The instructions you are receiving are your copies. Feel free to make any notes you would like on your copy. Your copy will be shredded at the end of the trial. I'm going to read the instructions to you. I invite you to follow along with me. You have found Jodi Arias guilty of first-degree murder. During this phase of the trial, you will be asked to decide whether the state has proven an aggravating circumstance that would make Ms. Arias eligible for the death penalty. If the jury unanimously decides beyond a reasonable doubt that an aggravating circumstance exists, the trial will proceed to the next phase to determine whether the appropriate sentence is a life sentence or the death penalty. You are allowed to discuss the case among yourselves during your deliberations on the guilt phase of the trial. You must now stop your discussions about the case until you formally deliberate again. In other words, the admonition is in full force and effect again. Do not form final opinions about any fact or about the outcome of the case until you have heard and considered all of the evidence, the closing arguments, and the instructions on the law. Keep an open mind. Form your opinions only after you have had an opportunity to discuss the case with each other in the jury room at the end of this phase of the trial. The law that applies to this hearing is stated in these instructions, and it is your duty to follow all of the instructions. You must not single out certain instructions and disregard others. The evidence you shall consider consists of the testimony already presented and exhibits that have already been admitted, as well as any other evidence that may be presented during this phase. It is the duty of the court to rule on the admissibility of evidence. You shall not concern yourselves with the reasons for these rulings. You shall disregard questions and exhibits that were withdrawn or to which objections were sustained. Evidence that was admitted for a limited purpose shall not be considered for any other purpose. You shall disregard testimony and exhibits the court has not admitted or the court has stricken. The lawyers may stipulate certain facts exist. This means both sides agree those facts do exist and are part of the evidence. You are to treat a stipulation as any other evidence. You are free to accept it or reject it, in whole or in part, just as any other evidence. In deciding whether an aggravating circumstance exists, you are not to be swayed by mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling. Race, color, religion, national ancestry, gender, or sexual orientation should not influence you. I do not mean to indicate any opinion regarding the facts or what your verdict should be by these instructions, nor by any ruling or remark that I have made. Performance of your duties as jurors is vital to the administration of justice. You are to apply the law to the evidence and in this way decide whether the state has proven beyond a reasonable doubt that an aggravating circumstance exists. In reaching your verdict in this phase, you are not to consider the possible punishment. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence, regardless of whether it is direct or circumstantial. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says, or part of it, or none of it. In evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness had any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before trial or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in the light of reason, common sense, and experience. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. During this phase of the trial, the parties are allowed to rely on the evidence already presented and argue about whether the aggravating circumstance has been proven to you beyond a reasonable doubt. Neither side is required to call witnesses for this phase. You may make your determination based upon the evidence previously admitted. The defendant is not required to testify or produce evidence of any kind. The decision on whether to testify or produce evidence is left to the defendant acting with the advice of her attorneys. The defendant's decision not to testify or produce evidence is not evidence of the existence of any aggravating circumstance. The prosecutor has the right to open and close the argument because the state has the burden of proof. What is said in closing arguments is not the law, nor is it evidence, but it may help you to understand the law and the evidence. The state has alleged that the defendant is eligible for the death penalty because of the aggravating circumstance that the murder was committed in an especially cruel manner. The law recognizes that all first-degree murders are to some extent cruel. However, this aggravating circumstance cannot be found to exist unless the state has proved beyond a reasonable doubt that the murder was especially cruel. Especially means unusually great or significant. The term especially cruel focuses on the victim's pain and suffering. To find that the murder was committed in an especially cruel manner, you must find that the state has proven, 1, the victim consciously suffered physical or mental pain, distress, or anguish prior to death, and 2, the defendant must know or should have known that the victim would suffer. In determining whether an aggravating circumstance is proven, you may consider only the aggravating circumstance listed in these instructions. The state has the burden of proving any alleged aggravating circumstance beyond a reasonable doubt. This means that the state must prove each element of each alleged aggravating circumstance beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced that the alleged aggravating circumstance is proven. There are very few things in this world that we know with absolute certainty, and in criminal cases the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that any alleged aggravating circumstance is proven, then you must make that finding. If, on the other hand, you think there is a real possibility that the alleged aggravating circumstance is not proven, you must give the defendant the benefit of the doubt and find the alleged aggravating circumstance is not proven. You must start with the presumption that the alleged aggravating circumstance is not proven. The state must prove any alleged aggravating circumstance beyond a reasonable doubt. I will complete these instructions with you after the matter is concluded. The state may now make an opening statement.
She made sure of it. She made sure that she killed him by stabbing him over and over and over again, and then finishing him off by slicing his throat. It is also sure that during this vicious attack, Mr. Alexander suffered. Mr. Alexander suffered pain every time that knife went into his body, every time that knife blade struck the back of his head, and when the blade went down to his throat. It was certainly also extremely painful. In addition to that, we know that he was alive in the sense that he was able to see, he was able to breathe, he was able to hear, so that he knew what was coming, forcing him to endure a horrific hardship, a horrific view of the world, mental anguish. One of the things that you heard during the testimony in the previous proceeding was that the defendant attempted to commit suicide. And she told you...
You may proceed.
During the previous proceeding, you heard the defendant testify about this suicide attempt while she was in jail. The preparations that she took, the towel that she supposedly was going to place underneath herself to catch...
Your Honor, I'm going to renew my objection. May we approach?
You may.
To get back to the suicide attempt at the jail, at that time you heard the description of all the preparations that she took. And one of the things that she told you, one of the aspects of that preparation was that she obtained some sort of razor blade and some sort of object that was very sharp. And she told you that as she began that suicide attempt, one of the things that she did is that she cut her wrists. And when she cut that wrist, she said, "I'm not going to go forward." She made a choice. And she made a choice to not go forward because it stung, because it hurt. She made that choice. Mr. Alexander did not have that choice on June 4th of 2008 as to whether or not he was going to endure a pain.
improper argument.
Overruled.
And his pain was much more severe than the one that she described, the one that made her stop. Each and every time that that blade went into his body, it hurt. It was more than a sting. It absolutely was excruciating every time that blade struck the back of his head.
Again, objection, improper argument. This is opening statements.
Overruled.
Every time that that blade continued to cut into him, it hurt him. He was sitting in that shower there on June 4th of 2008 in the master bedroom shower, and there were some photographs that were being taken. And the last photograph that you see without any motion on it is when he was sitting there, and you see the lower quadrant of his body. And as he sat there, the defendant took a knife that she brought. And she took this knife and she stabbed him in the chest area. There were 3 strikes that she delivered as she, according to her testimony, was squatted down. That is painful if we are to apply the standard the defendant has laid out for us. And during that first portion of the attack, Mr. Alexander suffered excruciating pain. One of those cuts, or one of those stab wounds, went into his heart. And it's something akin to a heart attack. At first, he began to lose blood, experienced shortness of breath, and then the chest started to tighten. So in addition to the initial, if you will, stab wound, when the nerve endings are cut, and he felt that pain, he was also beginning to feel the pain of his heart running out of blood as the blood kept seeping out. The other thing, as he sat there, was that he was extremely afraid. He was terrified.
Objections beyond the scope.
Overruled.
One other thing, 2 individuals that testified for you previously were Janine DeMarte and Richard Samuels, both of them with PhDs. They talked about the fight or flight syndrome, and that the reason that you have that is because you are confronted with such a scenario that produces these actions. But it's because of fear that these fight or flight symptoms arise, or that is something that they discussed. And in this case, the person that was presented with those choices was Mr. Alexander as he sat there in that shower, because he had already been stabbed. And so as he sat there, and after having been stabbed, had to make a choice. Fight or run. But he's laying or sitting on his backside, and he's already bleeding out, and she's got the knife, and the door is small as he sits there. So there is no way for him to really do anything other than what he did. Fight, defend himself. And that's why you see on the left hand the defensive wounds. And what he tries to do, as he tries to reach up, is to try to take the knife away from her. And instead of being able to grab...
This is argument.
Approach, please. May continue.
You've been given the jury instructions to talk to you about circumstantial evidence. And the circumstantial evidence is going to show you that as he sat there, because of his defensive wounds, he attempted to grab the knife from her. But you also heard from Ryan Burns that this individual that sits here in court today is pretty fit, is very strong. And Mr. Alexander was sitting down in an inferior position to defend himself. So he reached up for that knife, and he cut himself by the blade as he grabbed it. And that also produced pain as he sat there and grabbed it on more than one occasion. Additionally, his right hand, he also has a cut in that. So he's sitting there, and now he's been cut not only in his chest, but he's also got these defensive wounds as he tried to fight. After experiencing this terror as he tried to fight, he sits there. Well, what does he try to do? then he undertakes flight. He doesn't go into the closet. No. He then goes towards the sink and begins to get there, or ambulate, walk, crawl. Gets there. And when he gets over to that sink, he's already hurting. He's already got the issue with his heart. And he's got blood coming from his hands, and he's got blood coming from his chest. And as he gets to that sink, and he looks, he can also see that this blood is coming down. Initially, he just looks down at it. But now he's able to see it, and there's this mental anguish associated with this blood running down. And it's hurting. His hands are hurting. It's not like it's just a paper cut. It's much more than that. It's a knife that has gone through the left hand on more than one occasion, and it's a knife that has also gone through his right hand. And as he stands there with his hands on the edge of the sink, he sees himself. But he's also able to look to the back because of the reflective mirror.
Objection, speculation.
And as he stands there in front of that mirror, as he stands there bleeding in front of that mirror, not only is he seeing himself, which is extreme emotional and mental anguish, he's able to see her in the back.
Yeah, objection calls for speculation.
Approach, please. You may continue.
Again, circumstantially, he's at the sink. He's already been stabbed. Everyone knows that there's a reflection that can be gained from a mirror. Everybody knows that when an individual is standing at a sink, they're alive, they're breathing, they can feel, they can see, and they can think at that particular time. And we know that the defendant then approached Mr. Alexander from behind. She started to stab him all over the back, all over in the back of his head. And as Mr. Alexander endured that horrific punishment, he decided to flee. He decided to move away from the attack. And he started to go down the hallway. And as he went down the hallway, the defendant was after him. He didn't make it all the way down the hallway. In fact, he made it to the area or the breach where the carpet started. And when he got there and as he started to go there, you can see by the rainbow on the wall that for him, that would be the end, and he went down. And he went down with his head up, facing up, so that As he sat there, he was still, or laid there, he was still alive, he was still breathing, he could still see. And the last thing that Mr. Alexander felt as he laid there, as he could see up there, was this knife, this woman, and this blade coming towards him. And it was only death that relieved that pain, and it was only death that relieved that anguish. And that is especially cruel. Thank you.
The defense may make an opening statement.
Thank you, Your Honor. Ladies and gentlemen, at issue before you at this phase of the trial, frankly the only issue before you at this phase of the trial, is whether the killing of Travis Alexander, the killing that you with your verdict have determined to be a premeditated first-degree murder, was committed in an especially cruel way. When you hear that issue posed to you, you may think, well, we've seen the photographs, we've heard of the wounds, we've heard of the slit throat. You think, well, of course.
Objection, argument.
However, the question before you is not one of cruelty. We can all agree that what happened to Mr. Alexander was cruel. And as a matter of fact, in the jury instructions were just read to you, the law recognizes the fact that
Approach.
So as I was saying, this isn't a matter of cruelty. The law recognizes, and what is in your jury instruction says, that all first-degree premeditated murders are to some extent cruel. As you process the evidence you're about to hear, as well as the fact that you can consider the evidence that you've already heard, the question is one, is that meet the definition of especially cruel? In that regard, the evidence you're going to hear about these wounds that happened, this sequence of events that supposedly happened in 62 seconds, pursuant to what the state argued during this trial, is whether it is, and the language in your jury instructions is such that it was unusually great or significant. Unusually great or significant. Is it beyond this normal cruelty that is inherent in any first-degree murder? That's the question before you. Talk about, there's two issues in that regard when you hear the evidence and when you consider the evidence that you've already heard. There's two issues. It is the pain and mental anguish of Mr. Alexander, but it also deals with should Jodi Arias have known, or should she have known, or did she know that she was causing this? Now in this regard, and we'll talk about this a little more at the conclusion of this phase, we have to account for the fact, and as the state just brought up, the testimony of Dr. Samuels, and as well as Dr. DeMarte, and you also heard from Dr. Geffner, about the synapses in the brain, about the flight or fight response of both these individuals. Because as you process this information and you hear from Dr. Horn talking about these wounds, the perception of both these individuals and how their brains were functioning in this time is relevant to consideration of this mitigating factor. And when you consider what you're hearing through this filter, through this light that the jury instructions impose upon you that are not optional, that you must follow, you will come to understand that the state has not proven beyond a reasonable doubt that this was done in an especially cruel manner.
The state may call its first witness. Dr. Horn, please take the stand. You are still under oath. Do you understand?
So can we approach before Dr. Horn speaks?
Yes. Ladies and gentlemen, we are going to take a 10-minute recess at this time. Please be back in 10 minutes and we will start promptly at that time. Please remember the admonition. You are excused.
Please stand for the jury.
Council, please approach. We are at recess.